Good evening, everyone. Jeff Jinks here, trying to talk about a really important case, an amazing case, really, that came down recently, just a couple weeks ago on January 11th, 2019. And it's a transaction on a breach of contract case. I'll give you the citation on Facebook here, but there are so many different elements to this case that are fascinating. I know you're going to learn something, and you're going to be surprised at how many different things came together on this case that you wonder, do these things really happen? Is it legal? I get comments and questions all the time when I'm out speaking from investors, and they want to know, can you do this? Can you do that? And how's it work out? So I'm going to tell you about this case. It's RCM Phoenix Partners versus 2000 East Meadows LLP. And this is a case about a breach of a contract. Simple, right? So it's a purchase agreement. And the, the first thing that I want to say is, yeah, purchase agreements do get litigated. They do. And this is a case where a buyer is litigating against the seller where the seller breached the purchase agreement. The seller broke it, not the buyer, right? So do people really sue on that? You bet. And here's the case. The very first sentence in the case is it says, this case is a 10-year lawsuit arising from a real estate transaction that did not close, right? So it's one of these deals where it's a 10-year case. Oh my gosh, it's unbelievable, right? You might be wondering, how long does a lawsuit take? 10 years. That's one of the longest I've ever seen come across from the court. So yeah, lawsuits can go forever. Transactions can go forever. A few paragraphs later, right? So here we are. It's a 10-year deal. Second, how much is this for? $9 million. This is a $9 million case where the buyer was trying to purchase an apartment community. So $9 million at stake, that's worth fighting for, right? And the case started because there was a purchase agreement between a first buyer and the seller, and then the first buyer assigned that right to another purchaser, right? So they flipped it. So it's all of you guys out there and women that are wholesalers and you're putting things under contract and flipping them to somebody else with an assignment. Guess what? The big guys do it too. It's a simple legal fact that you can assign a contract for valuable consideration. Here's a $9 million deal that went down on an assignment, just like a typical wholesale transaction that you hear about all the time. So we got a 10-year deal, we've got wholesaling, we've got assignment, right? We've got a seller breaching their agreement. Unbelievable. So that's just the beginning. That's the first page of the opinion. So what happened here after the assignment? Well, the buyer was going to pay money, cash money, and they were going to assume the seller's existing financing. So you've got another common element, kind of like it's like a subject to deal, right? You've heard of that. I always get like my stomach in a knot a little bit when people talk about subject to, but here's a $9 million subject to deal on some apartments. So fantastic. So they're going to assume that loan, and they go through the due diligence part, and they're working with the bank to get their assumption approved. It's not done yet. They get an extension. It's still not done yet. They ask for another extension, and that's when the breach occurs. The seller says, "No, I'm not going to give it to you. I'm in bad faith." And then as part of all that, there were some, oh, guess what? Some enforcement on code violations against the apartments that hadn't been disclosed. So that's another aspect of the breach where the seller knew of enforcement actions by the city and county for property conditions and didn't reveal them. So here we are. You've got everything. You've got assignment, you got wholesaling, you got flipping, you got a subject to deal, you've got code enforcement coming in there, and you got $9 million on the table. Wow. So here's what happened next, right? So as part of that, the buyer filed what's called a Lis Pendens. I know it sounds like I can't talk. Lis Pendens, Lispendens. Pendens. That's litigation pending. It's Latin. It's one of the few phrases that we still use in Latin in real estate, but it's been around forever. It means that you have a claim against a piece of real estate, and there is litigation pending regarding that real estate. There's a whole statute on it. We use this on kind of a regular basis. I don't say it's all the time, but whenever there's a dispute, we file a lis pendens. And the reason that you do is it ties up that property and it puts the title company on notice and other buyers or third parties on notice that, wait a minute, somebody else has got an interest in this property and there's a lawsuit. So if the title company didn't pick it up or your broker didn't pick it up when you're doing the deal, it's going to show up in a special place, a special docket called the Lis Pendens docket, and it's then a public record. And that's what this case really was hovering around. It wasn't all the other things that I just went through that are common, typical, but maybe sophisticated and complex techniques used by investors all the time. But we're seeing all of them in this case, including the lis pendens. So what happened in this case is the parties were litigating officially before the Court of Appeals whether or not the lis pendens was proper, whether or not there was a breach or not that was actionable. And ultimately, the Court of Appeals sided with the trial court. They affirmed the trial court's decision. The lis pendens was proper. It was correctly done because it was mandatory. Basically, if you have an interest in property as part of a litigation proceeding, and it's privileged, so it's not a slander on title. You hear that sometimes, like a mechanic's lien maybe would be a slander on your title, and we include that as part of our litigation sometimes. So the seller was saying, hey, this is an impermissible slander on title. It's affecting us. It's a cloud on title, but the legal action is slander on title. And so they had to go through it, and the Court of Appeals says, no, it's the correct way to do it. The buyer did everything it was supposed to. The party who's liable here is the seller. They did everything wrong in the case, and that's where it ended up. So hope you've enjoyed it. I really enjoyed this, learning about this case and reading it. It had so many amazing elements in it that we deal with on a regular basis, and you wonder if these things really come up in real life. Yes, they do. Not just small investors, but super big, gigantic, nationwide investors doing it as well. So hope you learned something. Like it, like the comment, post it on, send it to your friends. Everybody needs to know about this case, and we want them to hear about it. Thank you very much.